Good morning, everybody, and thank you so much for joining us on our latest installment of our School Law 101 webinar series. Today, my partner Allison Matthews and I are going to be talking about the reforming APPR model. Nothing like a light summer dive into APPR at 8 o'clock in the morning. You folks who are joining us are truly brave. We're going to cover just the recent legislative updates on APPR, talk about some of the timelines for implementation, and discuss the differences in negotiability and other considerations between the old framework and the new framework that was rolled out in 2024. If you're joining us for the first time today, just a little bit about this webinar series. About 3 years ago, we started hosting a School Law 101 topic approximately once per month on the third Thursday of every month at 8 a.m. To cover a variety of topics that pertain to either instructional, personnel, or business topics for our school districts. A little bit about Bond's practice. We represent approximately 200 school districts statewide. We have school attorneys in most of our major offices around the state. So Allison, for those of you who do not know her, is based out of Long Island. For those of you who do not know me, I'm based out of Syracuse, and Kathy, our marketing, our guru here who's on the line, is also based out of Syracuse with me. So without further ado, we'll get started with the presentation. I anticipate we have about half an hour to 45 minutes this morning, and feel free, if people do have questions, to put them in the chat, and we will try to address those if we have time remaining. Thank you so much.
Thanks, Kate. So I'm going to kick it off. And even though our names are here on the title page, I do want to thank Emily Fallon, who helped put our materials together for us and was a crucial member of our team here to get this presentation ready for everyone. So, what is APPR? So we originally had this introduced in 2010 with some revisions in 2015. This might bring back some painful memories of everyone who was scrambling to negotiate and put these plans in place with the threat of state aid looming. And fortunately, at least that part of it is gone, which we're going to talk about a little bit too. Some of the criticisms that happened with regard to the 2015 plan was that student performance piece that was mandated, and a lot of that sometimes you had teachers who would inevitably be evaluated high because they had high achieving students, and also on the flip side where there was a lower achieving population. So there's a lot of criticism on that too. There was a lot of opt-out that was going on too in terms of parents not wanting their kids to be part of this. So we're overhauling that, and we're moving forward. So we're no longer doing a one-size-fits-all in terms of student scores, and we're getting rid of that punitive penalty with the state aid, and really leaving it up to each local school district and BOCES to construct a plan with very few, guidelines in terms of what this looks like. This new legislation is really a shell, and it gives you a lot of flexibility to decide how it is you want to evaluate your teachers and your principals. Kate, do you want to take this one?
Sure, yes. So just how did we get to the 2024 amendment? So as referenced, this was a bill signed into law on June 28th, 2024. And like Allison said, this new framework establishes a much more flexible framework than the historical framework that we've had since 2015, that is less focused on objective student success measures and more standards-based and broader. So the new legislation establishes a new standards-based framework. It's known as the STEPS program. And the concept is that, like Allison said, this is a rough framework that is intended to be standards-based rather than numerically performance-based, and that returns considerable control to local school districts and BOCES. Now, as we'll get into later, that local control can be both a blessing and a curse, of course, because without the framework of the prescriptive APPR legislation that we had since 2017, we default in many instances to the standard PERB negotiability rules. And that is a lot of what drives what is going to be either mandatorily negotiable or dictated by the statute in many instances. But the goal was to return flexibility and control to local school districts, to eliminate some of the objective measures that were based solely on, for instance, student test scores, and to eliminate, like Allison said as well, some of the penalties that were associated with noncompliance. So although I'm not aware of any districts that actually had their state aid withheld for failing to get in an APPR plan, for instance, or failing to report their scores to the state through the portal, that was always a threat hanging over us, and that threat has now been removed. And the other big change as well is that you all probably remember in 2015, we all had to change our tenure appointment resolutions because there became penalties associated with the tenure timelines for people who didn't receive satisfactory HEDI scores. Those penalties and mandates have also been removed, which we'll get into in just a while. You want to take this one, Allison?
Sure. So we have a tremendous amount of time to get these plans in place. And as you're going to see as we go through this, you really have that blessing and a curse. It's a framework that you get to work under. So you have a lot of time to get it done, but they're leaving a tremendous amount of discretion in terms of what the plan looks like. So this, looming deadline that seems very far away might really sneak up on you. But Kate, how many districts do you know that actually have their plan and their new plan in place?
I don't know any. So we have received some questions from districts who have had their APPR agreements expire and are wondering about how to move forward from there. And obviously, repetition of the old framework is not advisable if you have an expiring collective bargaining agreement. But absolutely, Allison, my experience has been the same as yours. That
Yeah, I don't have any at this point,
Yeah.
and that's fine. I think a lot of people are waiting for there to be a template out there that they can work off of because there is so much discretion that's involved here. But in terms of this lengthy timeline that you have, think about the fact that you're going to have to negotiate this new plan with your teachers union. You're going to have to negotiate with your administrators union. And you may want to look at, when does your next collective bargaining agreement expire? Do you want to be doing this on top of negotiating a contract? Do you want to have it be a standalone? Do you want to look at what are the things that your district really wants to see in a teacher evaluation and a principal evaluation plan? And do you need to gather some data to figure out what that looks like? So there may be a lot of planning, but always keep in mind when your contracts are going to be expiring, because to do this on top of a contract, depending on how contentious your negotiations are going to be, you may just have a little bit of negotiation fatigue by the time you get to this evaluation plan. And you really should try and get this one right the first time and how you want it to look, because you're going to have to negotiate out from under it once it's in place. So again, it's a locally developed plan. We're reverting to traditional Taylor law rules in terms of what must be negotiated, unlike the prior framework where there were some things that were district decided and there was no negotiations over it. We're not really seeing that here. So we're going back to that traditional model where there's a lot of flexibility and a lot of discretion, which yields things that must be negotiated. So yes, a lot of time, but it likely will sneak up on you.
Oh, we note as well too that a question we do get recurrently is, what is the current status today, right, prior to June 30, 2032? And the answer is what you have in place until you negotiate something new. I know Allison hit on that, but I wanted to make that very clear. You're not making any changes absent negotiation to your current scheme, even though that current scheme may have been based on the 2015 APPR framework.
Right. And even though the mandate to use the student scores goes away, there's nothing even in the new legislation that prevents you from using them. I think most districts will probably want to get away from that, but there's nothing wrong with keeping that in place until you have a new plan. And there's likewise nothing wrong with incorporating it into your new plan if you choose to go that route. Kate, you want to take this one? All right.
Sure. So yeah, I think we'll tag team it. So
Sure.
So again, we in the absence of a really clearly delineated framework with certain components like we had under the 2015, like Allison said, we revert to the traditional PERB rules in terms of what is mandatorily negotiable about the new framework and what would be subject to management discretion. So the law states that all of these plans must be the result of a collectively bargained agreement between the district and their unions. And again, this is applicable. We should clarify as well, there's often confusion about who evaluation frameworks are applicable to, and we're talking about classroom teachers and building principals. Some negotiability elements that would be mandatorily negotiable in your new framework. And again, this comes from both the language in the new law as well as just traditional PERB principles and case law that pre-existed the APPR framework. The actual assessment forms themselves. So if you're using a rubric, we've seen things like walkthrough tools developed. Typically, PERB requires those to be negotiated in the event that they're used for individual evaluative purposes. If you're going to utilize observations, which we'll get into when and how those are required, it's more flexible than under the old framework. The number and type of observations would be something that is is mandatorily negotiable. However, as we'll explain a little bit later, there is a specific statutory minimum requirement of observations for probationary educators. For tenured staff, they're permitted to be evaluated on a cycle as negotiated between the district and their bargaining units. So, you could have a situation where where tenured staff rather are evaluated on a 2-year or a 3-year cycle. If you choose to do that, the cycle itself and the duration of that cycle is something that would be mandatorily negotiable, with that
On
impact.
this one too, the minimum for a principal, because they're the other component of this, I think we all sort of revert to referencing educators because that's the bulk of who we're evaluating. There's a mandatory building visit, which we're going to get into. So that's something, the number and the fact that that must take place, that's not negotiable. You have to hit that minimum number required by law. If you want to, you can't go below that. If you want to go above, that's fine, but you can't eliminate this observation component or the building visit from your plans. They're required.
Who conducts the evaluation? Similar to our traditional APPR framework? Who conducts the evaluations, and whether you choose to use internal administrators versus peer reviewers, their credentials, et cetera, would be something that is also subject to negotiation, as there's no minimum standard set forth in the new law. If you decide to, for instance, utilize a rubric that assigns certain weights or measures to certain components, that framework and that calculation and rubric would be something that's subject to negotiation. Now, the next one is somewhat interesting: use of evaluation results in employment decisions. So it's well established that tenure is a decision that belongs to the school board. So historically, that's been not only not a mandatory subject of bargaining, but actually a prohibited subject, because the board does not have the authority to waive its ability to make tenure decisions. And I don't know if you're all similar to the districts I work with, but Allison and I were chatting about this last night. The thing is, since 2015, the ability to terminate probationary teachers automatically on the basis of a low APPR score of developing or ineffective, in my experience, has been used extraordinarily infrequently. It really did not move the needle forward or give districts a quicker path towards, exiting underperforming educators, in my experience. So this is something that in all likelihood, we're going to advise that you simply don't address, because if it is not addressed in terms of the use of evaluation results in a tenure decision, the board can still utilize that information as making a tenure decision. The only case where it would be mandatorily negotiable that we could think of would be a situation in which you want to say, mirror the old law, right? And say that if somebody gets a score of X, Y, and Z, they are automatically disqualified from tenure. But you don't need to do that, because that practical result can be affected simply based on management prerogative and prior interpretations of the Taylor law. You all may recall as well that under the 2015 framework, you were required to negotiate an appeal procedure. We saw a lot of variability in those procedures statewide. Some of them were just a second hearing with the superintendent. Some of them permitted board level reviews. Some of them incorporated by reference the grievance and arbitration procedures in the CBA, which Allison and I really, really don't like at all. That's really bad. So there are a lot of those. This new law does not require that you negotiate an appeal procedure per se. But if you wish to have an appeal procedure, that would be something that, because again, the law, where you're hearing a theme here, because the law is silent on that, that would be something you would have to negotiate with your impacted bargaining units.
Just before we go on to the next slide, because there's so much involvement from unions in the creation of this plan, their incentive to create an appeal procedure where they can essentially wipe out the score, I think, kind of goes away, because they're deciding, and with you, how these evaluations are conducted, what we're weighting, how we're what our score is that we get to at the end. So it's not so much draconian, where the school district has a lot of say into how this is being done. There's a lot of input in here. So hopefully the back and forth on the appeal procedure, and that being an issue that is stops you from getting your plan done, is going to go away as well. So going to the evaluation system and what it looks like. So we're moving away from APPR as a term, and we're going to this new acronym of STEPS, which stands for Standards-Based Educator Evaluation and Professional Support Plans. So for our building principles, we're going back to the standards that are set forth in the 2015 Standards for Education Leaders. There's a citation there to the regulation where those standards appear. And for classroom teachers, They have to be observed and evaluated based upon the 2011 New York State teaching standards, which are also embodied in a commissioner regulation. So I'll continue on. That last slide was pretty quickly. So as Kate mentioned, we're getting rid of the heady bands and we're changing to numbers. So we now have scale 1 to 4, with 1 being your lowest and 4 being your highest. So 1 is significantly below expectations, and all the way up to number 4, which is exceed expectations. So this would be an example of something that's statutorily prescribed. So you have to use these levels 1 to 4. You can't go back and say, well, I want to stick with the heady bands. I want to do something else here. This is one of those areas that there's no negotiation over. This is how your plan has to appear. So you have to ensure that all personnel are able to achieve a rating on each of the standards. So for the 2015 ones for the building principal, the 2011 ones for the classroom teachers. So they have to get a rating on each of those standards. And so the 1 through 4 on each of those, and an overall rating. But how you come up with the overall rating and how each standard is weighted, as Kate mentioned before, that's something that's going to be subject to negotiations.
And the standards, we're going to do a deeper dive on that in a couple of slides, but this, just to be clear so everybody understands what we're talking about, the standards we're referencing that are specifically enumerated in the regulations are they're academic standards. These are not student test score based metrics like we saw for the SLOs in the traditional APPR framework. It's a really different and much broader and more flexible framework of academic standards than we're accustomed to under the traditional APPR model.
Kate, you want to take this one?
Sure. So the STEPS plan, as Allison said, is now essentially the replacement for the APPR plan, and there are certain mandated components to that plan under state law. One of them is a description of the measures used to evaluate the extent to which the educator meets each of the applicable standards. Again, these are going to be different for principals versus teachers, and they're specifically enumerated in the regulations. The extent to which those standards are tested is also and assessed, and at what frequency and what cycle is something that is going to have some flexibility for tenured folks, which we'll talk about in a while as well. The description of how the selected measures are specifically going to address each of the standards in the regulations, a description of how evaluators who are actually conducting the training are going to be trained. So this is similar to the standard we had under the old framework, where the lead evaluator had to have certain training and credentials in assessment and classroom observation. The criteria under the new law are not nearly as strict as what we had under the prior set of regulations, but there is a requirement of a description of how people will be trained. Description of the process for developing and implementing a formal professional development plan. So this would be how you plan to, improve teacher performance. Description of the frequency of observations and school visits. And again, for certain teachers, the untenured teachers, there's a requirement of observations that is stricter than for tenured educators. How the methodology will be developed for how educators are going to receive that 1 through 4 score, and how that's going to be calculated, and how they will be a description of the frequency with which they'll be evaluated on each standard. So again, not every standard needs to be assessed in every single evaluation cycle. There's some flexibility around that. Now, there's also the concept of teacher and principal support plans for teachers and principals who are rated unsatisfactorily with a score of 1 or 2, level 1 or 2. These are very similar to our traditional PIP or TIP framework that we're accustomed to for improving performance. How training as well on how the STEPS plan will be implemented, any certifications that are required for implementation of the plan for anyone who's charged with evaluating teachers, and any others. There's a catch-all here as well for any other criteria determined required by the commissioner. So that could be in forthcoming regulations or guidance. When APPR rolled out in 2015, you all may remember too that the state pretty promptly put out a extensive manual with several hundred question and answers to address the state's mandated performance framework. And we don't have a Bible per se on this from SED, but I'm expecting more guidance will be forthcoming as we are, as Allison said, quite far away from 2032, thankfully. We can also presume, and we don't have any intel that would confirm this, but I think we can all presume as well that NYSET's going to be working on this extensively and likely coming up with their own workflow for the standards, their own rubrics, their own proposed measures, and all of that as well in the upcoming years. So we also want to be prepared with our own thoughts on that as well.
They will likely issue marching orders to all their LRSs to make sure everyone's trying to be consistent throughout the state. So there's that piece too. We're going to dive in a little bit more to the one piece of the plan that is mandated, at least the specific one. We have this shell of a framework that Kate just went through here, but your plan as part of evaluating must include observations for classroom teachers and school visits for principals. But the frequency and how you conduct them, that's going to be a product of negotiations, so long as you meet the minimum that's required by the new statute. So evaluators conducting the observations in the school visit, that could be an administrator, it could be a peer review, or you could have an independent evaluator. Again, that's going to be subject to negotiations. There's no more remote, however, for this. So if we have another pandemic, this, of course, is going to be one of those emergency executive orders, but hopefully not in any of our lifetimes. But there's no more remote observations or school visits. They have to be conducted in person. So they have to also occur they have to have a sufficient number and duration so that an evaluator can collect meaningful evidence that we're looking at the teaching and the leadership to evaluate whatever standard it is that they are looking at. So there's a lot of flexibility here. I know that a lot of districts find it to be challenging to make sure they get in all the observations that are required under the current APPR framework, and this will give you a little bit of a reprieve. But also keep in mind, what does your district want in terms of accountability, and how do observations and school visits fit into that? Because for those who are the tenured staff who are on that multi-year cycle, do you still want a school visit once a year, even though you don't have to have one once a year? So what does that look like? Is your public, your community going to want to see that you're still looking at these buildings and these classrooms at least once a year or twice a year, whatever your number is, even though the law isn't requiring you to do so? So think about that in terms of resources versus what your overall goals are and what you want your plan to look at when you try and decide if you want to go above the minimum floor that's set forth in the new framework.
And going along with that as well, keep in mind, based on the prior slide as well, part of the STEPS plan has to also identify the training for evaluators. So as you're thinking about staffing that observation and walkthrough piece, that's another thing to keep in mind, that anybody who's conducting those, if they're then part of the formal STEPS process, is likely that their credentials and training and qualifications are something that's likely going to be part of that STEPS plan as well. So we certainly don't want to overcommit in the sense of, committing to a level of formal observations through staff that requires very specific training or credentials, right, that we can't ultimately deliver on. So that's something to keep in mind as well.
So here's the minimums that you have to meet. So for your probationary staff, there must be 2 observations or building visits per year. And for tenured personnel, it's twice in a multi-year cycle. So this is that area of flexibility where you can negotiate over how long the cycle is going to be and how often you want, whether you want more than 2 visits. So do you want your probationary staff to be observed more than twice? Do you want your tenured personnel to be observed or have that school visit more than twice in a multi-year cycle? And how long of a period of time are we talking about? So we don't see anything in the new legislation that prescribes a cap on how long this multi-year cycle here is. So again, this is something that you have to look at, and how much accountability do you feel like you need when it comes to observations and building visits? Is that something that you really think needs to be happening at least once a year, twice a year, or whatever the frequency is on the multi-year cycle? That's something that has to be negotiated, but it's something you should be prepared when you go to the negotiating table to back up in terms of what you want and why it's important. So we have an annual cycle that's for all probationary employees. That's non-negotiable. So we can't do anything less than that. We can't do anything more than that. It's annual. We have more flexibility when it comes to our tenured staff.
The floor is mandated. The ceiling is something that's subject to negotiation with tenured folks. So this is what we referenced earlier, one of the interesting dimensions here that makes this very different than, for instance, the Danielson or the NICET rubrics that you may be accustomed to as part of APPR. We referenced previously that the STEPS plan needs to be based off of these New York State learning standards that are set forth in regulation. And they're referenced again under here, the regulatory references for principals versus classroom teachers. Not every single prescribed standard needs to be assessed every year for each tenured individual. That is something that can be subject to negotiation. As we said previously, the STEPS plan is supposed to outline the method by which all of those standards will be assessed, eventually as part of a cycle, but they do not all have to be assessed in every single year as they were under, for instance, the Danielson rubric. So like I said, for building principles, the standards are in the regulation that's on the slide. So probationary teachers and principals, however, do not have the same flexibility. They have to be assessed on each of the required learning standards applicable either to principals or classroom teachers as appropriate every year. Now, nothing prohibits or prevents non-probationary teachers and principals from receiving annual ratings, but like Allison said, the floor is set by law. The ceiling for tenured employees is subject to negotiation. So you can go above and beyond the cycle concept and make that an annual cycle like it traditionally was. But in order to do so, your unions would have to agree.
And on this first bullet point, again, think about what you're administratively able to track. So if you're not doing the every criteria, every standard, every single year, is everyone who's tenured on the same track? Because if you have one group that's being evaluated on standards 1 to 3 and the next on 4 to 6, that could be really burdensome to keep track of. So kind of keep in mind what you want that to look like. And maybe your position would be that every cycle, or if you want your cycle to be a year, that you want everyone to be evaluated on all those standards. But again, it's just, you have to make sure that you can track this and it doesn't become more burdensome than it's intended to be. All right, so the famous evaluation standards, here they are. All right, so again, these are embodied in regulations. So for the teachers, and these are very broad, so there's a lot of things that you're able to do here. So knowledge of the students and the student learning. So you have to evaluate your teachers on that standard, but how you go about doing that is open to discussion with your union and negotiation. So again, it's that blessing and a curse. There's a ton of flexibility here. But again, there's a ton of flexibility here. So what, these things, to how you look at them, it can be challenging when you're trying to fill in the details with this framework. The next one, knowledge of content, instructional planning, instructional practices, the learning environment, the assessment of the student learning, professional responsibilities and collaboration, and professional growth. And then on our principles, how they're achieving the mission, the vision, and the core values, their ethics and professional norms, their equity and cultural responsiveness. I know a little bit of a hot button issue these days. Curriculum, instruction, and assessment, the school community, because our building principals are tasked with that as well. Their professional capacity and practice, the professional community that they've developed in their buildings, how they engage with families and the communities, how they manage their operations and their resource, and their continuous improvement in that particular building.
So with respect to evaluation criteria, teachers and principals shall also be evaluated using one or more of the following measures in addition to in-person observations. And there's a series of enumerated examples in the new law, included portfolios, surveys, and feedback, professional goal setting. Student outcome data can, like Allison said, it can be part of your negotiated STEPS plan. Or another locally developed measure. And again, that all of these pieces, because of the flexibility that's provided in the law, would be subject to negotiation. This is similar to the artifacts sort of process that would be gathered as part of the traditional APPR framework. Any measure used for negotiation or for evaluation rather, shall provide direct evidence of the teacher or principal's practice that appropriately and accurately assesses the degree to which they meet standards. So that's the purpose of the use of any of these artifacts, is to provide that direct evidence that provides the basis for the numerical rating of 1 through 4.
Right, so supporting professional growth. So we need to have a system in place for supporting the growth of any teacher or principal who needs that extra support. So this is going to be pulling data from various sources to identify the individual needs of that educator. And we have to use data from the evaluation itself to review the student progress, sustaining professional growth, and assessing the efficacy of the professional learning system. So we're always looking at our plan and making sure that it's actually working. On top of that, we are, for anyone who's receiving a 1 or a 2, they have to be assigned. This is, again, mandatory. So we're not going to be negotiating over this. Although if you want to do more than what the law requires, you certainly can. But we're required to give those individuals professional, personalized professional support plans. And that has to be done by October 1st of the year following the evaluation. So this, again, is the floor. So we have to make sure we give these plans. October 1st is the deadline. Your union could turn around and say, we want it before the beginning of the school year. So that would be subject to negotiations if you want to do more than what you're currently directed to do under the law. And it's the same timeline that we're currently using for those improvement plans under the existing statutory framework. All right, so we have to develop these support plans. This is the superintendent or their designee that's going to work on these. There's, again, a framework for this. So we need to identify the areas and the needs where someone needs to grow and be supported, how the employer is going to support that growth in the identified areas. There need to be measurable goals and timelines for meeting these. So the more specific you are in these, the better, especially if you want to use this to make any employment-based decisions, that it's concrete, it's detailed, and the individual knows where they're falling short and what they need to do to get there.
So again, we have significant differences based on what the status of a principal or teacher is being tenured or probationary. So we just want to kind of refresh and review some of those distinctions because it's a critical difference in the new law that is different than what we've had historically. So the first item that we've identified is that with respect to tenure versus probationary, a tenured teacher or principal may receive differentiated evaluations and therefore not required to receive an overall rating every single year. Again, it's based on a cycle, and that cycle can be multi-year. We saw a question in the chat requesting if there's any sort of parameters around the length of the cycle. And as we noted, for tenured individuals, that cycle is subject to negotiation. There's no minimum or maximum there. Contrast that with probationary teachers and principals who must, in other words, that's the floor, must receive an annual rating on each teaching or leadership standard every year, as well as an annual overall rating. That rating can be spread out over multiple years as part of a cycle for the tenured folks. Another key difference is that for tenured individuals, the observation and school visit frequency may vary. There's not a requirement of having, as we've had in APPR, the two unscheduled, two scheduled for all employees. There's differentiation between tenured versus probationary. And not all standards need to be assessed each year. They simply have to be assessed over the course of an evaluation cycle, which could be multi-year. Tenured educators are required to be observed at least twice per cycle. But again, that cycle can span multiple years. So you could have a situation where those two observations are not being handled on an annual basis, although walkthroughs are generally a matter of best practice. And a lot of districts conduct walkthroughs for non-evaluative purposes too, we should point out. And there's nothing in the law that would change that existing PERB precedent that authorizes that. Probationary teachers and principals, conversely, must be observed and have a school visit annually on all standards at least twice per year. So again, that's the floor. I believe it's the ceiling too, right, Allison? Because that's what the law says. I don't think it would be permissible to negotiate above that, right, with probationary folks. But certainly they could on tenure. What do you think? Do you
You
think
could go above that floor. I think the odds of you actually being able to negotiate that are pretty slim.
I'm pretty low. So practically probably unlikely, but legally, theoretically possible, I guess we'll say. Then the final distinction we want to make is that for tenured teachers and principals, they must receive a formal support plan if rated a level 1 or 2 based on a locally developed plan. And with respect to probationary teachers and principals, they must receive a formal support plan annually. And if they're rated 1 or 2, the district has to then implement that PIP or TIP as well by November 1st. In terms of tenure and probation too, one of the things that we also want to note is that you all may recall the beginning in 2015, we had to all change our appointment resolutions to reference that certain APPR scores of effective or highly effective were required during certain years of service during the probationary period in order to obtain tenure. That is no longer the case. So anyone who was appointed under resolutions post 2015, but who is still probationary in your district should be reviewed, because if they were appointed with that APPR language, that is no longer applicable. So even in the absence of those APPR scores, they would be tenure eligible. It's not a bar to tenure anymore. You may not want to tenure them. And again, the board owns tenure, so that's not something that's subject to negotiation. But that requirement that a person was automatically disqualified if they obtained a ineffective or developing rating is no longer applicable. We also have an interesting side issue with JURIMA credit as well that Allison and I have been discussing with our practice group. But you may also remember that in order for a teacher to obtain 1 year of probationary credit for substitute service of a regular and consistent duration immediately preceding the probationary appointment, you had to have an APPR score for that year of substitute service. That is also no longer required under the new law, because the new law repealed all of those adjustments to JURIMA credit and are no longer applicable. We are not recommending that boards go back and retroactively, revise all of their resolutions, because that seems like a lot of busy work that is unnecessary, given that the law preempts anything that's inconsistent. But you should be calendaring these, because one's, teacher tenure timelines, for instance, that you may have calendared on a 4-year cycle may actually be entitled to a 3-year cycle, depending on whether they had that regular substitute service. And it can come up for tenure in prior districts as well. So if you have any of those specific situations, of course, we'll reach out to your favorite bond attorney to talk through that. We've been all discussing it with our colleagues as a practice group as well. And I think we have a pretty good lay of the land on those tenure issues. So.
And we're recommending going forward that you adjust your resolutions to go back to the way it used to be done, but don't worry about revising the ones that have already been adopted. But going forward, you really should take that information out. So training evaluators. So, we have a lot of flexibility in terms of who's going to do the evaluations, but it's up to the district or BOCES to provide the appropriate training to the evaluators before they can be permitted to actually conduct a teacher or principal's evaluation. So there is a training course that meets the minimum requirements. So we usually recommend that if there's a training course that's out there and you know that that's going to meet the requirements, you're in pretty solid ground if that's the course that you have your evaluators go through and finish before they can actually conduct the evaluations. All right, so I think we talked about this a little bit already. So we're allowed to grant tenure regardless of the APPR score, unless there's some sort of restriction in the collective bargaining agreement, which it's unlikely. I've never seen one of those. We don't have to use those scores anymore for tenure decisions. If a board wants to, they certainly can. But there's no longer a bar to achieving tenure, as Kate had mentioned. And we both agree that piece of the legislation didn't really do a lot in terms of getting to a point where someone is up for tenure and it's, oh, wait, can't do it. They have these scores. That it really didn't happen. I think for some of it is that if someone wasn't meeting those standards, many times they're exited before they get to that 3 or 4 year mark. So we never really get to the bar. Otherwise, it's just something that was denied and we moved on. So it didn't really move the needle much here. This expedited dismissal provision that probably was also not really used.
I never used it. I'm not sure if you did, Allison. I certainly never used that provision ever.
Right. So and that's gone. So that's another area where this is gone immediately. And we're going to touch on this again in the presentation, but because there's so much flexibility, that also yields a lot of subjectivity when you're doing evaluations. So the need here for a lot of paperwork and documentation to make sure that how you're conducting the evaluation, how someone is scored, what went into that score is really going to be important here so that you can maintain as much consistency within this rather subjective framework. We want one more bargaining one. So some things you might want to think about in putting together your plan. So, we all love our pedagogical and competency 30-20 A's. They can be a bit of a nightmare to litigate, and they can be difficult to prove as well. But if there's some sort of a challenge that's going on to your evaluation system that is overlapping with your 30-20 case, you may want to limit what types of challenges can be done through your actual steps plan versus dealing with it in the 30-20 proceeding, because there are inevitably going to be decisions issued at different times, and it might be more appropriate to bring that up as part of the 30-20 rather than separate from that process. And the last piece of it is also making sure, as Kate mentioned before, we agree on this. So we don't really want a lot of back and forth on the final score.
We don't want teachers going to arbitration over whether they
exactly,
get a 3 or
to
4.
take that they take that final score out of your control. That doesn't make a lot of sense. It's arbitrators are not educational background. All of them, some of them do, but a lot of them don't have that educational background. They certainly weren't involved in the evaluation process. So giving them the ability to say, oh, this 3 really should have been a 4. It's just not a great system. So we want to make sure that if you do have any sort of appeal process that's in your plan, that it really goes to the superintendent or the board, and it's more of that discussion with the superintendent or the board. I would prefer in this case, I would think it would be the superintendent, someone who's involved in those evaluations on a day-to-day basis. It's not really something the board's going to get involved in, but they have the final decision. And it's not really, it's a conversation. It's worded here on the slide as a grievance, but we'd really prefer it be an appeal, not a grievance, but an opportunity to discuss the evaluation with the superintendent ultimately making that final decision, and it's binding on the person who was evaluated.
So potential risks and landmines that we see with the new legislation, that evaluation criteria without standardized testing across New York State, as we said, flexibility is a blessing and a curse. And that's one of the questions that, I've just been hearing in the field the most, which is, how are these standards going to be actually assessed, right? In the old framework, it was easy. You would simply negotiate a SLO that was based typically on a state assessment result or a regents result or something else that was objective and, student performance based. That, as Allison said, that elicited a lot of criticism from the field, that it was particularly unfair for struggling districts that struggle with student achievement, for districts with a high percentage of L and disabled students, for instance. So there's a lot of criticism for that objective, standards-based measure. Now we have a much broader standards-based system that, as you saw from the chart that is embedded in the PowerPoint, those standards are very broad. They're not, what is the score on the 11th grade ELA test, right? It's a lot broader. So that is both a blessing and a curse. And without the, the kind of field guidance from the state in terms of how those standards are supposed to be assessed, there is some ambiguity there that we think could result in significant variation around the state and how those standards are assessed. The unions are likely to raise roadblocks at each and every opportunity they can in this process in typical fashion. So we expect objections and pushback on evaluator training, the specific rubric design. As Allison and I said, we think it's highly likely that NYSET already has their LRSs statewide trying to develop unified rubrics that they're going to present to you and expect you to utilize. And just because there's concerted action there on their part doesn't mean that you have an obligation to accept those rubrics that are presented, but we expect to get a lot of pushback, and that certainly be an area that's subject to negotiation. So if agreements cannot be reached, obviously, with the unions, then there's always that risk of an increased frequency of improper practice charges, as well as potentially contractual grievances if there's other issues in your CBA that are triggered as well. Now, the other piece too is, historically, like we said, since 2015, the absence of an acceptable APPR score was resulted in an automatic denial of tenure. And that is no longer the case. So this really reinforces the need for having whatever standards-based system you come up with for developing your plan has to also ensure that there's clear documentation that supports personnel decisions. And of course, as we know, we've had trainings before, we can document performance issues and conduct issues outside of a formal evaluation process. And nothing about this law changes that. You can still issue counseling memos and, and address performance issues. But I think the broadness of the new law and the kind of, again, that flexibility in the new law creates the risk that documentation is also not going to be as objective and robust as what it was under, for instance, a Danielson rubric. And there's both pros and cons to that, but it does underscore the need for clear documentation going forward. Do you want to take this one, Allison?
Yeah, sure. And just there's a question here about the standards for principals. So it's the 2015 standards that were referenced earlier. That's going to be your framework. That's the framework you should be following. And also the teaching standards as well. I happen to have the teaching standards in front of me. So as we have, there's these broad standards, but the document, it's, that if you Google it, you'll probably come across it. It's entitled a steps planning tool. You probably can't see it, but it looks like this. But there's standards and there's multiple, it looks like a checklist. There's multiple little details that also check boxes that kind of flesh out what you're supposed to achieve in terms of meeting each standard. So for the teaching aspect of this is just the one I happen to have in front of me. This is really going to be a good tool when you're trying to fill in the details of that framework that is so broad, that blessing and a curse. So your plan needs to be put up on your website so that everyone can see it. And it's similar to in terms of parents and the ability to get the overall score. That's something that remains part of the plan. So it's not subject to FOIL, but it's the current teachers of their children. The last time I looked into this, when it was someone who actually asked for the score, because they frankly don't see it all that often, there was nothing that prescribed how you go about doing it. You don't necessarily have to provide a copy of it. There's some flexibility. It can be a phone call. But there was an obligation in the current statute to make sure that the parent understood what the process was and what that evaluation went into. So we'll have to look into that in terms of when you get these requests. But that's something where I would definitely contact counsel so we can guide you on the best way to relay that information to the parent. And I think that's going to be something as we get closer to 2032 that we'll probably have a better handle on, because there'll be some more guidance on that one. And I think we are. So there's one final question here. Can we share the document we're referencing? I thought there was links embedded in the PowerPoint. So if there's not, we will work with Kathy to make sure that the people who are registered for this receive the links to the teaching standards and the building leader standards. So you all know that framework that you're working under when you're creating these plans and you're able to access it. So I don't know if we have any other questions. We almost hit right on the nose how much time we thought this was going to be taking today. So I find that when people leave presentations and conversations that there's something they thought of that they afterwards that didn't necessarily come up while they're watching the presentation. Again, we're 7 years away from this being a deadline, so you certainly have a lot of time to digest this and really think about what you want your plan to look like. But we're in that sort of blessing and a curse. So as we get closer to 2032, we are anticipating that more information and more guidance will become available that will help you fill in the blanks of really a skeletal frame here that you have to work with. But we encourage you to start thinking about what you want your plan to look like, especially when it comes to those multi-year cycles, how you want to accomplish the goals, what kind of things your community will be on board with. Do you want to use that portfolio option? Those are things to start thinking about so that when you go and sit down with your unions, you already have a clear path to what you want to achieve. There will definitely be some back and forth on that, but the more things you have lined up before you hit the bargaining table is always put you in a better place. So we'll leave it to that. If you have any questions, you can get in touch with us. Our email addresses are on the firm website if you don't already know who we are and have access to us on a regular basis, but we're available even for those of you who don't work with us regularly to answer any questions you may have. So thank you very much for coming to today's webinar. I'm just looking at this one more question that just rolled in. So let me try and answer that first. Okay, so as far as the change about not having to dismiss a teacher with it, right? So the part about the APPR scores, that's gone regardless of whether you're under your old plan or you go under your new plan. So if you have a resolution that says someone can be granted tenure provided that they at least have these APPR scores. You
No longer enforceable.
Right, you can't enforce that part of it. So that's immediate. That went in effect right away, as did the state aid penalties. So that goes whether you have a old APPR, whether you keep that up until 2032, you can't enforce it anymore. So regardless of which plan you're under, the APPR score in terms of a bar is no longer in place. You can also, of course, look at evaluations behind closed doors and use that as part of the board's ultimate determination whether to grant tenure, but that absolutely you can't grant it. That's no longer there.
And that's even if you're utilizing your pre-existing
Right.
APPR framework. You
Correct.
would still continue to use that framework because that's what you negotiated with your bargaining units until something new is developed. But even if somebody gets a 1 or a 2, that would not be an automatic bar to tenure is what Allison's saying.
Right, correct. All right, so I think that may have been our last question. So again, thank you everyone for being with us this morning, and we hope you have a great rest of the day and rest of the week.
Thanks, folks. Have a great week.